Stand by, of course. Let's go to Shannon Bream, who's reporting from the steps of the Supreme Court. Shannon, what can you tell us?
Well, I can tell you it's a 5-4 opinion. It's a win for Hobby Lobby. And as you all have discussed, it does specifically say in the holding that the contraceptive mandate as applied to closely held corporations. That is a distinction here because both of the companies, and there is another one with Hobby Lobby in this case, are family-owned, closely held corporations. So this ruling is for them. But essentially in this opinion, 5-4 opinion by Justice Alito, the split you would expect with Kennedy going with a more conservative wing, says that in holding that the HHS mandate is unlawful, we reject the government's arguments that the owners of companies forfeit all their protections when they decide to organize as corporations rather than as sole proprietorships. And basically it goes on to say that the regulations here violate the religious freedom as under the federal law, the Religious Freedom Restoration Act, which prohibits the federal government from taking any action that substantially burdens the exercise of religion unless it's the least restrictive means. And what I've read of the opinion before, and it is a big one, but so far what we see is basically the reasoning from Justice Alito is that this isn't the least restrictive means. Women have other ways to get this birth control. It's not that they're banned from getting it, but in this case there's got to be a workaround where Hobby Lobby does not have to underwrite or provide cost-free access to 4 of the 20 contraceptive methods that are covered by the HHS mandate. Those 4, they believe, trigger abortions. They don't see them as birth control pills or something along those lines. They distinguish them. They are talking about morning after pill, IUDs, things they believe that once there's a fertilized egg can end the pregnancy. Justice Kennedy wrote a concurring opinion, meaning he goes with the majority here, but he wrote his own opinion. I'll have to look at that. He's obviously the key swing vote here. And one of the key problems he had during oral arguments was the fact that this law and these requirements came not from an elected body, not from Congress, not from one of the 3 branches, but from an unelected bureaucracy, the Department of Health and Human Services. He found it very troubling, at least during the oral arguments, his indication was that an unelected bureaucrat could set this policy. At the time it was Secretary Sebelius, now we have Secretary Burwell, but basically it was someone that was not elected or part of the 3 branches as outlined in the Constitution was handing out something so sweeping. And so you can hear the protesters here, a lot of cheers, some happy faces, some sad faces, depending on where you were on this issue. But basically what it boils down to, for these closely held corporations, the government cannot force them to comply with this mandate. If it does so, it would violate the law that gives them religious freedom protection. It doesn't look like the court actually went the next step to consider the First Amendment analysis, instead finding that under that Religious Freedom Restoration Act, the owners of these companies are protected. The dissent, also very lengthy, authored by Justice Ginsburg, and she starts out with a discussion of women having equal opportunity in the workplace, and I'm guessing, just reading the opening to her dissent, that she's going to see this very much as a gender equality issue. The 4 justices who normally side together on that side of the bench are together on the dissent today. Guys.
Very, very interesting. Shannon, thank you very much.